Right, so today we're looking at the question of bail. Question of bail. What is bail? Bail, B-A-I-L, is freeing, giving a man his freedom, giving a man back his freedom on conditions pending the outcome of his matter before the court. The first thing I would like to say about that is that every citizen of this country is entitled to his freedom. His freedom is a right guarded and protected by the Constitution. When your right is taken away by a member of the Jamaica Constabulary Force, the member of the Jamaica Constabulary Force are obliged to consider bail for you. In fact, the Constitution says if you are taken into custody and your freedom is taken away, you can't be held in custody longer than 48 hours. And if you are, and you're not charged, you must be charged or released. If none of those two things happen, then you should get counsel who will make what's called a habeas corpus application. But I'll talk about that another time. So, what the police ought to do once they take you into custody and they say they're investigating the case, they hold you for a maximum of 48 hours, then they bring you before the court and charge you, bring you before the court. Once they bring you before the court, the first court you will face is the resident magistrate's court. The resident magistrate is obliged to hear an application for bail for you. Now, the application for bail is usually made by counsel for the defense, the accused person being the defendant. What will happen is you're taken into custody and your relatives will seek and find counsel for you. Now, depending on counsel's seniority and competence, they can charge anything from 50,000 to 100,000 Jamaican dollars, which isn't really a lot. Because what you really want, what the defendant really wants, is to get out of custody. Because to be in custody is awful. I wish I had another word. I can't find another word off the top of my head. Your freedom is curtailed. You can't even use the bathroom as you feel a mind. On top of that, the lockups where you're kept is inhumane, it's dirty, it's nasty, it's stink. In addition to that, other inmates might want to harm you because you have something they want, or they just are bad people. In addition to that, the police might rough you up. So the first thing an accused person wants is to be allowed out on bail after he's arrested and charged. Now, once you get counsel goes to court on the first occasion and the matter comes before the court and he rises. He says, we should make an application for bail. The RM will say, learned clerk of the court, let me hear what the allegations are. Now, once you go into the court, you say to the clerk, I represent Mr. XYZ. I need to see the file. I need to know what the charges are, what kind of obstacles we're looking at. The clerk of the court is obliged, by virtue of practice direction from the High Court, to hand you, as defense counsel, all their materials, everything. They may not have everything on the first day, but they must give you all of what they have, copies of all of what they have. Now, once you get copies, you can take 10 to 15 minutes, peruse the documents, see what the allegations are, and in your reading, identify what the weaknesses are. Because once a clerk gets up and says, Your Honor, it was 6 o'clock in the evening, accused was known to complainant before, held him up with a gun, took away his property and ran down the road. You have to find in there some measure of weakness why the court should consider granting bail. In addition to that, you have to be able to say The accused will find other place to live. He won't live in the community if that's an issue. He won't interfere with the complainant. He's not a flight risk, etc., etc. Prosecutor may object or may acquiesce. That is to say, he does not object. If he objects, he has to say why he objects. And even having said why he objects, a court may still grant bail. But once he objects, you have an uphill battle, or we call a basket to carry water. But let's say you granted bail, you get bail. Bail sum, or what we call a quantum, will be dependent upon the gravity of the charge. So if it's murder, if you get bail in murder, maybe $1 million, 500,000. If your defense is live, if you have like ID defense or self-defense or something like that, and it's real live, that will affect the quantum of the bail. So you get bail in whatever sum, and the judge will say 1 to 3, 1 or 2, or 1 to 4 sureties, whatever number of sureties. The bigger the number, the bigger the quantum of bail, the more sureties will be granted. So what do you do now? You get your sureties together. Sureties have to now bring their proprietary documents, that are documents that say we're the owners of land at so and so, and the value of the land, because you have to have the amount of, you have to have, the property has the value of the bail, the quantum of the bail. Then the sureties have to bring 2 passport size photographs, national ID, letter from a JP or a sergeant saying they are who they say they are. And some judges like to have a utility bill also. You go to the court's office, present the documents. The court staff, court officers will accept the documents if everything is kosher. And then the sureties must sign the bail bond. Now what this means is, if on any given day after the accused has taken up his bail and he's free on his own now, if on any given day he doesn't come to court, a judge going to order the warrant, bench warrant, defendant not appearing, bench warrant to issue. Once a bench warrant is issued, the surety is the next, because they're going to execute the bond, which means they're going to come for the surety. The surety will now have to pay the sum for which he stood bond. And if he doesn't pay, he'll be taken into custody until he pays. So it's a very, very serious matter, this question of bail. And you have to abide by the conditions. Judge may say curfew order, stop order, surrender travel documents, report to the police station nearest to you every Monday, Wednesday, and Saturday. If you don't do those things, bail will be revoked. If you commit another offense while on bail, bail will be revoked. If you don't come to court, bail will be revoked. So, you need counsel to make the application for bail. Counsel is indispensable in this regard. The fees are not that high, but you pay for what you get. There's no guarantee once you pay a lawyer to get bail for you. There's no guarantee that you'll get bail. There's also no guarantee counsel will even make the application, because when counsel peruses the materials presented to him, disclosed to him by the Crown, if he's of the opinion that it's not prudent to make the application at that time or at all, you have to stand by counsel's decision. Because counsel's mind is indispensable in the process. You have to trust him. So he has to be very careful who you choose to represent you. Mind you, the Norman Manley Law School has produced some of the best attorneys the world over. Jamaica has some of the best and well-trained lawyers. So you have quite a few to choose from. Choose the best and have faith and confidence in the lawyer you choose. Well, good.